testimony against him continued throughout the week, including Perry Mason-like moments where one of his top executives just admitted to the underlying fraud. Also, Trump dismissed his $500 million lawsuit against MeidasTouch network host Michael Cohen because Trump was too afraid to show up for his deposition that was supposed to take place in New York early next week. Next, we go to Washington, D.C., where federal judge Tanya Chutkan rejected Donald Trump's attempt to delay the proceedings in the prosecution by Jack Smith for Trump's attempt to overthrow the 2020 election. Donald Trump also filed a motion to dismiss the indictment in the case before Judge Chutkan. Trump cited presidential immunity for his ability to try and overthrow our democracy, which is frivolous on its face. We will discuss. Trial is scheduled in that federal case for March of 2024, and no indication Judge Tanya Chutkan's going to move that date. Compare and contrast the law and order Judge Tanya Chutkan with the corrupt and incompetent Judge Aileen Cannon, because next we go from Washington, D.C., and we head to Florida, where Judge Aileen Cannon, the Trump-appointed corrupt stooge, ordered a temporary stay, or basically a indefinite delay, of the classified discovery deadlines as she contemplates moving the entire discovery and trial schedule. Trial is scheduled in the Florida case for Trump's theft of classified records for May 2024, but based on what Judge Cannon is doing, I think that will be delayed. Finally, we go to Georgia in the RICO case against Donald Trump and dozens of other co-defendants, where Judge Scott McAfee, presiding over the Fulton County District Attorney case, is controlling his docket, seems to be enjoying his job a lot, and denying efforts by Trump's co-defendants to play games and try to get their cases dismissed. The first trial of Trump's co-defendants, Ken Chesebro and Sidney Powell, is only a few weeks away. And guess what, folks? It will be broadcast live right here on the MeidasTouch Network. I'm Ben Meiselas, joined by Michael Popok. Excited to be here this weekend and share with you another busy week. You know, on LegalAF, there's a lot of episodes that we do that lead up to big things going down. This is a week where big things went down, and because you've been following all of the trials, tribulations, developments, everything that's been going on over the past few years by watching LegalAF, you all know all of these developments, so it all makes a lot more sense when the events go down. Michael Popok, how are you?
Ben, I'm doing great. It's a breathless week. We have a prime example of Donald Trump continuing to confuse spectacle of a train wreck as his cases careen with political viability and electoral viability. Just this week, off the list that you just made, and I'm sorry for everybody. I'm in transit. I usually carry around my little Popok Porter board. I don't have it today. We'll tell you why later. Ben and I are having dinner together in the same
dinner
place,
after AF.
Same time zone, same place after AF. Just this week, we've got Donald Trump filing a motion to dismiss the Stormy Daniels hush money cover-up business record fraud case in New York. He dismissed the Cohen case. He dismissed the case against the trial judge in the civil fraud case, Judge Engoron. He has moved to stay and lost the attempt to stay that case that's already in the second week of trial, which was denied. He has moved to delay the Lago case and seems to have a willing participant in Judge Cannon in that. He's moved to delay or dismiss the District of Columbia Judge Chutkan case. That isn't for the month of October or the quarter. That was for the week, as his team of lawyers, which consists of about 4 people, as they battle against the heavily resourced, the United States of America, scramble to try to outflank Jack Smith, or Fani Willis, which is almost an impossible measure. They've decided, obviously, they had a checklist that they wanted to do to kind of narrow the issues and try to apply their resources as they try to play zone defense against the United States of America. And so, there was a list that said, we got to dismiss the Article 78 against Judge Engoron. We got to dismiss the case against Cohen so he doesn't give a deposition. We got to delay Mar-a-Lago. We got to delay hush money, delay. And that was the list. And somebody, like some young associate, was like, got it, and started drafting. And then they started firing it all out, hoping to catch Jack Smith flat-footed. We know that's not going to work, but we got a lot to unpack and analyze here to explain what that list means. But as I said at the top of my piece here, this is just a political train wreck and a legal train wreck, where Donald Trump once again confuses that he's getting notoriety from acting out and lashing out and violating all the gag orders with some sort of electoral viability.
So Donald Trump's been engaged in the exact conduct that we're seeing kind of jam-packed in this 1 week over 4 decades. He is the definition of a vexatious litigant. He files lawsuits on frivolous bases to try to harass and destroy people's lives, and he puts tons of money into it. But then when his bluff is ultimately called, he dismisses those actions. And then when Donald Trump is a defendant, he tries to delay, use every type of scheme. There is no shame, like where certain people would feel like, I can't possibly do that in a court of law. I will be laughed out of there. He doesn't give a crap. He will just do whatever it takes to try to undermine the judicial system, not just the litigants involved. And so we saw this $500 million harassing lawsuit that he had filed against Michael Cohen back in April. Michael Cohen, my co-host here on the MeidasTouch network of the Political Beatdown podcast. And Cohen's like, bet, okay, I'll take your deposition and let's schedule it. And Trump tried to delay, and his lawyers made all of these arguments that legacy media doesn't cover. We cover here on the MeidasTouch network, but this is where I mean, you have no shame. Trump's lawyers argued, knowing that legacy media doesn't pick it up, that Trump would be too embarrassed to show up for his deposition, that Trump thought it could harm his reputation even more. And then Trump said in another filing, after he got it extended once, Trump said that he was going to invoke his Fifth Amendment right against self-incrimination, even though he says it's only the mob that pleads the Fifth and I can't wait to testify. Legacy media picks up the part where he goes, I can't wait to testify, not the part where his lawyers are filing in court that he's saying he's too scared to testify. He's saying it in court filings, and legacy media just ignores it. But when push comes to shove, Donald Trump always surrenders. He has this Teflon Don BS crap that the media projects to try to further his fascist ends, but he's not. He's very, very weak. And here, I'll give you some receipts. Here's the dismissal of the case that he filed against Michael Cohen. Donald Trump, by and through his counsel, dismisses that case. In the same week, Popok, you mentioned before, he dismissed the Article 78 lawsuit that he filed against Judge Engoron. He filed a lawsuit against the judge presiding over the case that the New York Attorney General has just brought to trial. He dismissed that lawsuit, stipulation withdrawing special proceeding. And then if you just go back at it, you take a look at some other examples as well. Not only is the Article 78 dismissed, there was also the dismissal of the case that he had brought against, and this was a while ago, when he sued New York Attorney General Letitia James. That was dismissed. He dismissed the case against her in the Court of Appeals. He dismisses all of these cases when push comes to shove. And so, you could be sure that if you just stand your ground and you keep going, that accountability will be here. But Donald Trump relies, the same way fascism relies, on people being worn out. So with that setup, I want to talk about what took place in New York this week. We had two major witnesses who testified this week. We had the outside accountant at the Mazars firm who testified. We had Donald Trump's in-house former controller Jeff McAfee testified, who went above and beyond the testimony that he had given at the Manhattan District Attorney criminal case where the Trump Organization was convicted of over a dozen felony counts. This was some, like, Popok, I know we like the Perry Mason style moments on TV where a witness goes, "We did it. I did it. I committed the fraud. It went down." And let's start with the witnesses. And let's start with, before talking about Trump's ranting and raving like a lunatic and the fact that he can't control himself and he attacked everybody and got a gag order imposed on him and that just looked like who he is, a reprehensible human being. Like, these witnesses, it was Perry Mason moment after Perry Mason moment. You've got McAfee going, "Yes, Eric Trump told me to inflate the valuations and deflate it. Yes, we committed fraud. Weisselberg told me to do fraud. Eric told me to do fraud." The testimony is that they all committed fraud. Popok, this was an explosive first week.
Yeah, it's a mastery of a trial process that we're watching in the hands of the Office of the Attorney General, doing a lot of things that would be a normal high wire act, where you're calling just to have a little breakout session for LegalAF Law School. It is the Attorney General's case in chief right now that we're in. Will be in that case in chief where she has the burden for probably the next, 60 or so, 60 trial days. We only saw week one of the trial, 5 days or so. It broke a little early for the long weekend, but there's going to be like another 95 trial days. And so she has to figure out with her legal team, Letitia James, how she's going to present her case and to get momentum, because you and I are trial lawyers, how to get momentum for your case. And usually you only call in your case in chief while you have the case witnesses that are friendly, that you control, that you know are going to testify because you've prepared them and you know what they're going to say. What you don't normally do is you don't call adverse witnesses, hostile witnesses, the defendants in the case, like Alan Weisselberg, the longtime disgraced, jailed, convicted CFO, chief financial officer, and his subordinate, the controller of the company, who reports to the chief financial officer. These are the two bag men and money men that are within the Trump Organization and have been there for 40 to 50 years. Okay, so they are defendants in the case. But Letitia James's team called them as witnesses in their case in chief. Weisselberg will be going next week. McAfee was brought in as a hostile witness, but the High Wire Act had a net underneath it for safety, because the Office of Attorney General knew what their testimony was going to be, because both of these gentlemen testified in the successful 17-count conviction of Trump Organization entities for tax fraud last year. People forget, I don't want anybody to get justice fatigue. He's not the Teflon Don. He's 91 felony indictments beyond that. He is losses at the E. Jean Carroll rape and defamation case. He is 17 counts of tax evasion conviction beyond being a Teflon Don, and other cases to come, including another E. Jean Carroll case that's going to start and other civil fraud cases. So she had the benefit, even though her office didn't handle the case. The prosecution was handled by the Manhattan DA's office. She had the transcripts of the sworn statements under oath, the testimony of Jeff McAfee and of Weisselberg. And so if they deviate from their testimony, and this, I said this in a hot take, this is how I used to discipline my witnesses at trial. I would just hold in my hands and I would just fold my arms like this, showing them that I had the transcript. I wouldn't even use it. I would just rock back and forth at the podium because they knew. And then I would just, like, sometimes if they were testifying, I'd open it. So they saw me opening it. This is my theater. My trial theater, and I would just look and then lower my glasses, and then they'd get back on track without me having to impeach them by saying, "Well, didn't you testify in front of Judge Merchan in front of a jury, and didn't you admit to tax evasion on behalf of the Trump Organization?" They didn't have to do that, And they didn't have to worry about getting access to those two witnesses, which I'm sure they did not have because they are defendants in the civil fraud case. All they needed to do was call them up and make them, one way or the other, conform and track the testimony they already gave last year. But even with that, the lawyer handling it for the Office of Attorney General, there were surprise moments because McConney, who got immunity to testify against the Trump organization in the tax case, he just gave it up really quick in the first 2 hours of his testimony, admitting that he participated in tax fraud at Donald Trump's and Alan Weisselberg's behest. And in response to the question, what do you think would happen if you didn't commit the tax fraud? And he said, I probably would have been fired. And this is a guy who's waiting on a $500,000 severance package because he recently left the organization. I'm not sure he's getting that severance package anymore. Note to Jeff McConney. But the great thing about what we're watching is that she has decided as the Attorney General that there are certain elements that she's got to address and carry the burden on in her case in chief, namely intent. That is the big, when people ask me on the street, pardon me, which they do, about the case, they say, what's the difference between what happened last Tuesday with the summary judgment and the first count of the complaint against Donald Trump and all the Trumpers for fraud and what they're trying right now? I said the biggest difference is intent. Last week, the judge was able to grant summary judgment to find persistent fraud over a at least 6-year period by all Trumps and Trump entities in New York business practice, but he didn't have to find, and the Attorney General didn't have to prove intent for that particular count. All the rest of the counts that are now up for trial for the next 95 or 100 days, insurance fraud, financial record fraud, financial statement fraud, and conspiracies around that, you have to prove intent if you're the Attorney General. So to prove intent, what better way to do that than to pull your first insider witness, one of the bag men, the money men for Donald Trump, stick him on the stand and keep him on track with his prior testimony. Otherwise, they'll impeach him and show that he's perjuring himself. And McConney didn't want it. That was like the third rail. McConney didn't want anything to do with perjury or impeachment. They never had to do that with him. He just gave it up in a package right away. So that was a bombshell moment. It's one of the reasons Donald Trump didn't want to be there for that. Everyone's like, well, he left because first of all, he was never going to go for any real portion of this trial. It's a 100-day trial. If he shows up 5 more times, I'd be surprised. He made a statement. He made it a political campaign stop with all of his breaks, but he wasn't going to sit in the room. For people that think he's there to intimidate people, like he'll intimidate the judge, that backfired, and I don't think that's what he was doing. And you would think if he was going to intimidate somebody, it would be Jeff McConney, his longtime controller, who's testifying against him, but he decided not to even be in the room during that testimony. In fact, Chris Keiss, one of the lead trial lawyers, wasn't in the room. He was busy filing his appellate papers, and they left it to Alina Habba. Talk about turning it over to somebody who's herself trial incompetent. You know, my favorite moment, Ben, then I'll turn it back. My favorite moment is when they're cross-examining McConney because he is, just another quick breakout. When you have your own witness, you can't lead your own witness. You have to ask them open-ended questions and let them testify, not yes or no, unless it's naturally a yes or no question. You can't do what we do, like you said, on Perry Mason or these law shows. Isn't it a fact that on November 5th you were? And, yes or no. That's cross. That's called leading. You can lead adverse witnesses when they get to the case on the defense, or if you call a hostile witness who's obviously hostile, you can start crossing. And if you're challenged, what I normally do is I'll start my cross by turning to the judge and say permission to treat the witness as hostile. And it'll be permission granted. And then you just go into cross. Now, they skipped that step because it was obvious to everyone but Alina Habba that when you call a defendant in the case into your case in chief, they are automatically, by their very nature, hostile. She had to stand up and say, they're leading the witness. And the judge was like, he's a defendant. He's obviously hostile. It's called cross. Try it
Alina
sometime.
Habba, you represent him.
I know, right? Who do you think this guy
He's supposed
is?
to be your client.
Yeah, he looks like Captain Kangaroo, but he is your client.
I mean, that's the thing. In all of the Trump filings, he's at least listed as somebody who's being represented by the Trump lawyer. So think about that when Alina Habba makes that objection. But I got to hand it to Alina Habba. I thought her cross-examination of Jeff McAfee was her best performance yet to date. I'm just joking. She didn't cross she didn't. She was too afraid to cross-examine Jeff McAfee, and there was no cross-examination of Jeff McAfee. So
Yeah,
Alan Weisselberg will. So just think about that, everybody.
Yeah.
So Jeff McAfee goes up there. He's a defendant. The New York Attorney General's office cross-examines him. They get him to admit, or he voluntarily admits, Eric Trump told me to commit fraud. Alan Weisselberg told me to commit fraud. It's basically all fraudulent, the enterprise.
And Trump would have fired me if I didn't do it.
Trump would have fired me. The Trump organization's a fraud. This is the guy who's worked there since like 1989. The guy's worked there his entire life. He's the controller of the Trump organization. Then the New York Attorney General sits down after that questioning. Then Judge Arthur Engoron goes to Alina Habba, who acts like she's so tough and that she's this expert trial lawyer, and she attacks the judge. Okay, Alina Habba, the witness is yours. We're not going to ask any questions right now. We reserve, Your Honor. We reserve. She sits there in front of that gamer laptop, which she claims is not her laptop or whatever, and she doesn't ask a single question. And then they go out, these MAGA Republicans, and then they whine. Oh, but the judge is saying it's a fraudulent valuation and Mar-a-Lago's really worth this and blah, blah, blah. Your controller just testified and admitted to fraud. Your organization was convicted of felonies about a year ago. Your outside accountant said that you committed fraud. In your depositions, your chief financial officer, Alan Weisselberg, says he doesn't know generally accepting accounting principles despite certifying on all of the financials they conform with GAAP, generally accepted accounting principles. Donald Trump says that he doesn't know generally accepted accounting principles and that Eric Trump was the one who handled the statement of financial conditions. Eric Trump, on his deposition, states that he's never looked at the statement of financial conditions, and Don Jr. thought the lawyer for the New York Attorney General's office was flirting with him when she said, "You don't know anything about generally accepting accounting principles, do you?" He's like, I don't know. I don't know anything. I just know that they're generally accepted. I mean, that's who we're dealing with.
And wait. And their CFO went to jail for 6 months for tax evasion related to payments that he received under the table for which they did not declare it, for which both Bender, so back to Bender for a minute. We didn't talk about Don Bender. The mastery, the masterfulness of this momentum that Letitia James is creating. Because as trial lawyers, it's not just random selection, like who we're going to call first, who we're going to call second. It is a methodical thought process that every trial lawyer undergoes about who's my best set of witnesses. The fact that after Don Bender and another outside accountant, Don Bender being not only their 20-year outside accountant for the Trump organization, but personal accountant for Donald Trump, Alan Weisselberg, Matt Calamari, the head of security, his son, Alan Weisselberg's son. I mean, this guy knows everything, and testified that he told them in no uncertain terms, which McAfee confirmed, that they couldn't do the bonus system because they were evading taxes criminally, putting their then general counsel's bar license at risk. This was Don Bender, who went on for a day and a half just dumping on Donald Trump and also reminding Judge Engoron as if he needed reminding, because there's nobody in the state of New York who knows the facts about the Trump organization, Donald Trump, and tax fraud and civil fraud than the Judge Engoron, who has sat through dozens of evidentiary hearings, read and listened to every deposition transcript. I mean, I said on one of my hot takes, I practice in this courthouse and in this courtroom, and I've never had a judge who's more prepared for a summary judgment. My judges are half as much prepared, and summary judgment is still being considered. There's nobody that was better prepared than him. And so with the testimony of all of these people, and now linking it together. When you start with, think about the momentum, Ben. Bender comes on and says, yeah, I was with an organization called Meiselas that was an accounting firm, and we had to disclaim 12 years of our audits with the Trump organization because we found the information provided by them was unreliable. Okay, let's dive into that and tell me, who did you tell in the Trump organization that they were committing tax fraud potentially, and what was their response? And then go through Weisselberg, go through McConney with them, go through Trump himself. How about this signature? Is that Donald Trump's own signature certifying the information that went to you is accurate and truthful? Yes. Did you rely on that in order to prepare the accounting statements and the tax forms? I did. What did it turn out to be true? No, there were things that were left out that I wasn't told. And then let's call the next guy who's an outside accountant. And then let's take two insiders who were convicted or have immunity from prosecution, who were at the very heart of all financial decision making along with Donald Trump. And let's go to them next, even though they're coming over from the other side of this case. And then this is only week one. Wait till the 60th day of her handling her case in chief. And there's one last thing, Ben, because we say this all the time, but I want our listeners and followers and watchers to understand this, and because you and I have been there. When the wooden doors of a courtroom close in the back, and you as a member of the bar are standing in the well of the courtroom, along with your counsel, along with the opponent, and you're putting on not the stuff that you're talking about at press conferences on the courthouse steps, but you're doing the painstaking, slow, and methodical presentation of evidence through witnesses, through documents, through transcripts, through videos, with a judge who is hanging on every word. I said in one of my videos, this is a bench trial. Normally, you put on a guy like McConney or somebody, and you go through checks, and the jury starts to flatline after the fourth check. Is this a check that was deposited in the endorsement on the back? But with this judge, he's like, tell me more. Tell me more about where that check went. When you have that, in contrast to the shit show, that's outside with Donald Trump, there's a big difference. Because when you're in that courtroom watching the mastery of the presentation of evidence, right? This, as I said, this is like a boa constrictor who is just around its victim and squeezing the life out of it over the next 50 days. Donald Trump can jump up and down and throw food at the computer screen and do whatever, and attack staff members and get gagged and do whatever he wants. But does not change the immutable facts that are being presented painstakingly by the lawyers and the judge that's going to decide it, and the appellate court that's going to back him up. That's what we're watching. That's justice. What's going outside during breaks and tweeting and social media, that ain't it. That's running for office.
And we need legacy media to talk more about what's going on in the trial with these bombshell revelations than asking Donald Trump when he's outside attacking a prosecutor, hey, what are you having for lunch, Donald? I mean, like, you see the media doing that. It just makes me so glad that we created our own media network. And have you heard the term mansplaining before? I've coined a new term, MAGA-splaining, which is kind of a form of mansplaining. It's when these MAGA Republicans or MAGA cult followers try to explain away Donald Trump's fraud or everything that he does. That's called MAGA-splaining. So when they go, everybody knows that the fair market value is substantially higher than the tax appraisals, to which I respond, okay, let's accept your argument as true. Number one, Donald Trump was the one who gave the valuation at what it was. So it's not the judge saying Mar-a-Lago is valued at this. The judge is restating what Donald Trump claimed it was to pay lower taxes. Number one. Number two, Donald Trump's employees, his executives for the past 25, 30 years, say he engaged in fraud, MAGA-splainers. And number three, even if you told me fair market value is higher than tax assessments, fine. I'll agree with you there. Not 5,000% higher, okay? That doesn't exist. And you don't just get to make up square footage. You don't get to say it's this size when it's actually that size. And so, no, stop with the ridiculous MAGA-splaining and let's focus on what the actual evidences to arrive at the truth. And that kind of brings me to this final point on this topic, at least, which is, Eric Trump announced that it was a big victory because the Appellate Department First Division, which is like one of the appeals levels court, granted Trump's and the Trump organization and Eric's motion to stay or just press pause for now on the dissolution of the Trump organization, the cancellation of the LLCs. And here's the thing about that. The main thing that Trump wanted was to stay the trial. That got rejected, as Popok said earlier in this episode. With respect to the dissolution and staying that, New York Attorney General Letitia James was not even fighting that. No one was arguing really even that the dissolution should have to occur immediately before the Court of Appeals makes its ruling. So it's not a ruling on the merits. It's actually, and if you've been following us here on LegalAF and the hot takes, we said that's what we thought was going to happen, and that's what we said we thought should happen. The fact that I think Donald Trump is a massive fraud doesn't cloud my sober analysis that you can't dissolve the business while an appeal is pending. Because ultimately, if the Court of Appeals overrules or overturns what a trial court judge, which I don't think is going to happen here, but if that did happen, you can't unring the bell if a dissolution had already taken place. So naturally, if you're appealing a dissolution order and a dissolution takes place before an appeal can be heard, that would be unfair to any litigant. That's why, as long as you just request the motion to stay, any court is going to grant that pending the appellate process. We said that's what's going to happen. That's what happened.
Yeah, let me give a comment
continuing. On that. Right. It's the furthest thing from a victory. It's just the standard procedure. And then the Trumps go out, look, the Court of Appeals agreed with us. They love us now. And it's like, that's not what they're saying.
So here's what happened. I mean, we just from my perspective, because I practice in front of the First Department, I'm a member of the First Department of the Appellate Division of New York. They finally got around, as you said, the Trumpers, to filing their motion for stay, which should have happened
September 26th, the day
10 days ago. You and I, if we were handling the Trump case, which we would never in a million years do that, but if we did, you and I would have typed up a motion, a stay, and an appeal waiting. We knew Engoron was going to rule against us, so we'd have like 30 pages ready to go. As soon as we saw the order, we spent an hour to conform our papers to what was in there because we knew what was going to be in there, and we would file it within a minute. And asked for the stay. They didn't do that. A week went by. You and I are scratching our head like, what are they doing? If they wanted a stay, you don't wait until like the second week of the trial to go ask for it. So they got another order. You did it on the hot take. We did it on the midweek of LegalAF from Judge Engoron, who then thought better about, well, wait a minute. I don't want them moving assets and changing corporations and to try to beat out my future judgment or the judgment that I've just given. So I'm going to issue a supplemental order that requires the Trump organization and Trump and all the Trumpers to reveal their corporations that they're thinking about incorporating and the ones that they have and any assets that they're planning on moving, and report that over to the Barbara Jones, the monitor who's been in place for almost a year on the original injunction that the judge entered related to persistent fraud way back when. And so they didn't like that order, including that, in fact, that it addressed entities that they said were not in front of the judge. And so they went, now we're going to file our motion for stay. And so they filed papers with the First Department. What happens there is one justice, in this case, Moulton, one justice looks at the papers and makes a decision, but wanted a hearing first. So while the courtroom trial was moving forward with the bombshell testimony that you and I just described, the lawyers other lawyers, including Letitia James, had to hightail it over to Madison Avenue and the First Department to go argue in front of Judge Moulton in person. And when we knew, and there's going to be a video, I'm going to look for it, of the on YouTube actually, for the First Department for the oral argument. But that argument has to be where Letitia James conceded that she is okay with that the entities are not dissolved and their certificates are not dissolved at the present time. One reason, as you said, Ben, is that seems consistent with somebody on the other side trying to appeal. The other reason is she wants them to be an uninterrupted going concern that generates money because she's going for $500 million at the end of the case. So fine, you want to keep your companies up and running. You don't want to throw people out on the street on payroll. Fine, keep making money. Every dollar you make is going to be mine one day. So I know that's why she did it. I am sure because she said it outside the courtroom. So I'm sure she said it in her oral argument to the judge. We're fine, Your Honor, with not having the dissolution happen, but the stay of the case. No way. You already the court already denied this 8 days ago. We're 4 witnesses into the trial. No, and the judge, this one judge, for now, said, I agree with you. No stay. Trial goes forward. And on the dissolution, since there's really no objection, I'm fine with putting a pin in the dissolution of the entities only for now, but then reinforce that every other part of Judge Engoron's order, including the requirement that Donald Trump turn over information about what his plans are to transfer assets to other companies, stays in place. Now, he's not the final appellate judge. There's a merits panel of 5. I think he'll be one of the 5 that will get assigned to the appeal on a slow track. That appeal on the summary judgment that was issued on last Tuesday, a week ago Tuesday, about whether Judge Engoron was right or wrong on summary judgment, that's on its own track. That may get decided before this trial is over. It's likely not to get decided before this trial is over. The trial on the other 6 counts and all the remedies that she's seeking, the New York Attorney General, including the big fat fine of disgorgement for $500 million or more plus interest, likely, that continues. So to answer the question, what does the appeal do? Nothing, because they asked for the stay of the trial and they didn't get it. And they're not going to get it from the big 5-person panel either. The 5-person panel will take a look at the papers. They'll get around whenever they feel like it to setting a briefing schedule. There'll be briefs. And 6 or 8 months later, there'll be an oral argument. Meantime, this trial will be over. And they'll have to, if they don't like the results there, they can appeal that. Look, in New York, unlike in other jurisdictions where I practice, you can appeal anything. You don't like an order in the case on discovery, on a deposition, on a sanction that you got hit with in the case. You can take it up on appeal during the case. They don't care. Unlike in other states, like in Florida where I practice, they could never bring an appeal on the summary judgment of one count. They'd have to wait till the end of the case to see when all the dust is settled if there's any reversible error. But New York, you drop a pen, you can appeal, and that's what you're watching. But so it did piss me off, and this is going to be part of a subtext of our presentation today, how pissed off I am when I read media reports. Sometimes we get hit with, well, you're just repeating what the media. We're not repeating what the media is reporting. We are our own lawyers and our own analysts of our own legal documents. And that's what you're hearing on this show, not something I read somewhere. So, we get the actual legal documents and pull them from the dockets and we digest them and analyze them with our experience. That's what you're watching. So it pissed me off when some of the reporting was Trump wins. Trump didn't win anything. You can't win that which the other person is willing to give you, which is the dissolution issue. And I think it's for the reason I said, Ben. She doesn't want to dissolve the companies right now. She wants to get the money banked so she can take it from them like taking candy from a baby at the end of the trial.
There's already an independent monitor in place. There's already a very strong order that would prevent Trump from transferring assets, as you mentioned. And so it's going through its normal course. It's going through the process that all of these cases would take. And as I've always said, you get the lawyers that you deserve. And Donald Trump certainly deserves these lawyers because there was a possibility too late now, after the summary judgment order issued by Judge Engoron on September 26th, if you're competent counsel, if you're competent lawyers, you file a motion to stay that night on the 26th, I could see a world where the Court of Appeals, the Appellate Division First Department here, would stay this trial and say, let's deal with the dissolution now on an expedited basis. Let's hold the trial. They blew it. They're now in trial for the next 85 to 90 days. We'll see if Donald Trump shows up even ever again. Trump's supposed to be a witness. I don't think he's going to show up. I think he's going to be too cowardly and say, oh, I'm going to invoke my fifth. This is a clown show. Whatever he's going to say, he's going to whine because he knows that 3 days on the stand getting cross-examined, I've studied his pathology now. I know he's too big of a coward, but ultimately,
but can I make one comment on that, Ben? Because I want to manage expectations. That just because he's not going to testify in the fraud case, and I agree with you, he's not. He has already testified in the fraud case. He decided to waive his Fifth Amendment privilege, having asserted it 400 times in a first deposition. He waived it and sat because he thought he was smarter than Letitia James, which he's not, and was going to talk his way out of this. And all she got instead was a 6-hour deposition transcript and video that she's both played in the opening of the case and will use. If he doesn't take the stand, this isn't a criminal case. If he doesn't, quote unquote, take the stand, his videos will continue to be used and put into evidence because they are sworn testimony as if he was in the courtroom. So there's no hearsay problem when you're playing the defendant's own sworn statements. So that deposition that he, for whatever reason, he decided to give instead of standing on his Fifth Amendment, and you and I speculated he was a little bit worried that under the assumption that a judge makes or a jury makes and is instructed that when somebody takes the Fifth Amendment in a civil case, you are to make an adverse inference that whatever was being asked is true, and they're just taking the Fifth in order to avoid it. That's the big difference in Fifth Amendment application in a civil case, which is what this is, even though it often sounds like we're talking about a criminal case. And so he didn't want that, so he wanted to go and give his testimony. We will see Donald Trump's testimony, even if he doesn't come into the courtroom to give it.
But if he's under subpoena by the New York Attorney General, unlike in E. Jean Carroll, where Roberta Kaplan, the plaintiff's lawyer, decided that she's fine not having him show up. That was a choice that was made. But if New York Attorney General Letitia James wants him to appear, he's under subpoena. He has to appear. He either would have to invoke his fifth as a reason not to testify, in which case she'll show the deposition, or he'll be held in contempt. But he can't just say, I don't want to be there. It's inconvenient.
I don't think he can take the Fifth. He's already waived the Fifth by testifying, and I don't think he's going to be able to show the basis and that he didn't waive already by giving his deposition testimony. So if she does decide that, talk about ballsy. I would love to see that. I don't know. I don't think she needs him. By the time she gets to her 58th day of trial, I mean, you and I are excited, and we're going to stay excited about analyzing this trial as it goes along. But by day 58, when she makes the decision, I now call Donald J. Trump, she may not need him, but she may want to do it just to roast him.
I think she's going to want to do it sooner than day 58. I think she's going to do Weisselberg. I think she's going to do Eric. I think she's going to do Don Jr. And I think then she's going to want to call him in the next 2 weeks.
And Ivanka.
But Ivanka. And Ivanka, absolutely. Yeah. But we will keep everybody posted. Yeah. I want to compare Judge Tanya Chutkin, the Law and Order DC judge who's handling the docket masterfully in the case against Trump set for trial in March of 2024. Let's contrast with Judge Eileen Cannon, the utterly corrupt and incompetent judge in the Southern District of Florida, whose various chicanery and machinations trying to delay, and it just looks sloppy and incompetent, also corrupt, but also very, very sloppy. Want to remind everybody as well, before we talk about those topics, check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. We don't have outside investors here at the MeidasTouch Network. The way we grow it is through our Patreon. Again, it's patreon.com/MeidasTouch, patreon.com/MeidasTouch. We have exclusive after show content from the MeidasTouch podcast. We have exclusive episodes that have already been posted that you can watch about Michael Popok's background, my background, Karen Friedman Agnifalo's background, how we all met. And it's a good way to support the growth of this independent media network. And I would just say this, if you are a member of our Patreon, put in the comments right now in this chat if you think the exclusive content is worth it. So in case anybody's on the fence, should I join patreon.com/MeidasTouch? Put in the comments how you feel about it. it, and you can check that out. We'll be right back after this quick break.
This is Michael Popok from LegalAF. If you're like me, you understand the pains of choosing what to wear. Let's face it, most clothes are uncomfortable, or too tight, or are never actually the size you really are. Not to mention the annoyance of trying to put a good outfit together. And when you do have a good fit, you can only wear it for a few hours before you have an important meeting or dinner, and then you got to change all over again. Everyone wants to dress the best and look good at all times because, frankly, it's a confidence booster. So here's the deal. Men's closets were due for a radical reinvention, and Rhone stepped up to the challenge. Rhone's commuter collection is the most comfortable, breathable, and flexible set of products known to man. And here's why. Rhone helps you get ready for any occasion with the commuter collection, which offers the world's most comfortable pants, dress shirts, 1/4 zips, and polos. You never have to worry about what to wear when you have the Rhone commuter collection. Rhone's comfortable 4-way stretch fabric provides breathability and flexibility that leaves you free to enjoy whatever life throws your way, from your commute to work to your 18 holes of golf. It's time to feel confident without the hassle. With Rhone's wrinkle release technology, wrinkles disappear as you stretch and wear the products. It's that easy. And with its Gold Fusion anti-odor technology, you'll be smelling fresh and clean all day long. And on top of that, Rhone is 100% machine washable, so you can ditch the dry cleaner altogether. I absolutely love Rhone. As you can see, this has truly become my go-to commuter fit and on the LegalAF podcast recordings. We're on the move a lot, whether it's jumping from meeting to meeting or catching a flight or an important dinner. The Rhone commuter collection has never let me down. The versatility and comfort of the collection is undefeated. Even after I wear it all day, I still feel super fresh because of that Gold Fusion anti-odor technology. The commuter collection can get you through any workday and straight into whatever comes next. Head to rhone.com/LegalAF and use promo code LegalAF to save 20% on your entire order. That's 20% on your entire order when you head to RHONE/LegalAF, promo code LegalAF. Find your corner office. Being on top of your mental health game is so important. As you know, I'm a practicing trial attorney in addition to my hot takes and co-hosting duties. And so it's easy to fall into bad habits or routines because life gets in the way, especially with your diet. Frankly, I think most people can relate that everyday life gets in the way, making it challenging to find a healthy snack without all the sugar and junk. If you're busy and constantly on the go like me, you need to try Mosh. It's a protein bar made for your brain. With 6 delicious flavors, each Mosh bar includes 12 grams of protein and is made with ingredients that support brain health like ashwagandha, lion's mane, collagen, and omega-3s. At 160 calories and only 1 gram of sugar, Mosh protein bars are the guilt-free snack your brain and body will crave. Your brain is your number one tool, which is why Mosh protein bars were mindfully formulated by some of the top neuroscientists and functional nutritionists. Mosh now has a new line of plant-powered protein bars in 3 delicious flavors. For those who want all the protein and brain support in the original bar, now made with plant-based ingredients. I have a Mosh bar midday to energize my end of day that's totally improved my performance. I love the taste, especially of the peanut butter Mosh bar. Delicious. Not to mention the packaging makes it super easy to take with me if I ever find myself hungry in between meetings. Don't settle for a mediocre snack when you can nourish your body and mind with the fuel it needs to succeed. So whether you're at the gym, on the go, or just living your best life, Mosh protein bars will keep your brain and body fit, fueled, and feeling good. Head to moshlife.com/LegalAF to save 20% off, plus free shipping on your first 6-count trial pack. That's 20% off plus free shipping on your first 6-count trial pack, which includes all 6 mouth-watering flavors. MOSHLIFE.com/LegalAF.
Welcome back to Legal AF. We are live. Special thanks to all of our pro-democracy sponsors for supporting this content, and round of applause to Michael Popok for those ad reads right there. Absolutely crushing it. I want to do the compare and contrast right now between what's going on in 2 federal cases against Donald Trump for crimes he committed. The Southern District of Florida case before Judge Eileen Cannon for Donald Trump's theft, willful retention of national defense information, classified information, top secret, sensitive, compartmented information. That case is set for trial May of 2024. And then Washington, D.C., the case against Donald Trump, also being prosecuted by special counsel Jack Smith for Trump's to overthrow the 2020 election. And that's scheduled to go to trial the first week of March 2024. And it certainly seems like Judge Chutkan is not going to be moving that at all. I think Judge Cannon is moving towards extending the trial date. She hasn't made that ruling officially yet. But I think Judge Cannon's going to be moving the May 2024 trial date, which, look, I'm not a big fan of Judge Cannon, to put it mildly. But the good news is that we're going to have a federal criminal trial that could put Donald Trump away for the rest of his life. That's going to take place in 2024. I can say that with a great degree of confidence that the trial will take place. Everybody in our system is entitled to a presumption of innocence. We can certainly talk about all of the evidence and my opinion about why I think he is very, very guilty in all of these cases, but ultimately it is a jury in our system that will make that determination, as it should. So let's start with Cannon, and then we'll go to Chutkan. I'll take Cannon. Popok can take Chutkan. Here was the order that Judge Cannon issued. Here it is right here, October 6, 2023. It's a paperless order staying SEPA Section 4 deadlines pending consideration and resolution of defendant's motion for a revised schedule for motions to compel and SEPA 4 litigation and the supplemental briefs on SEPA Section 3 signed by Judge Cannon. Not a great order right there, right? Let me break down what that means, because it probably sounds like a bit gibberish. SEPA is the Classified Information Procedures Act. It deals with how you deal with classified information in a case like this one, where there's willful retention of national defense information that happens to be classified information. Judge Cannon didn't issue a protective order pursuant to SEPA, which is necessary in all cases involving the Classified Information Procedures Act. She didn't issue it until mid-September, September 13th. The indictment was unsealed in June of 2023, and special counsel Jack Smith had the protective orders ready to go. But Judge Cannon didn't issue the protective order. Trump's lawyers dragged it on. They did their delay tactics that you see in all of these things. Judge Cannon let it take place and then finally issued the protective order for SEPA, the correct protective order, but it took her June, July, August, September, basically 3.5+ months before it was issued. And then Jack Smith turned over the records right away, except Jack Smith didn't turn over about 5 classified documents because pursuant to SEPA Section 4, which I just discussed, Classified Information Procedures Act, Section 4, the government can request, instead of providing the actual classified document in the SCIF, which is where all classified documents have to be reviewed in SEPA cases, sensitive compartmented information facilities, the government can say there are some documents that are just so sensitive, like nuclear secrets and others, we don't even want to show the criminal defendant these records. Even though a criminal defendant has the right and due process rights to get discovery, they shouldn't be able to look at these documents that they stole or engaged in misconduct with ever again. So instead, SEPA Section 4 says, government, go to the judge on an ex parte basis, an expedited, confidential basis, and then ask the judge if you can do a summary of the documents instead of actually making the classified documents available. And so that's what Jack Smith was going to do. The deadline to do that's October 10th. And Donald Trump argued, we haven't gotten 25% of the classified documents, and Judge Jack Smith's not complying with his discovery obligations. And first off, 25%, Trump uses that number because what we're really talking about is 5 or 6 documents of the 30 or so count. So it's not millions of documents. Jack Smith turned over millions of documents. We're talking about 5 or 6 documents. And special counsel Jack Smith's like, we turned over everything starting September 13th. So we did what we were supposed to do. Judge Cannon, you're the reason why there's this delay. And we're following SEPA. We're not required to turn over those records. The very point of this deadline on October 10th is so you, judge, can make the determination if our withholding of these 5 documents, providing a summary instead of the classified documents, is appropriate or not. That's what we're following, what the strict text of SEPA actually says. That's not a delay. That's what the procedure is. And Judge Cannon was like, I am temporarily staying all of these deadlines because of Donald Trump whining that he didn't get these classified records, which he's not supposed to get. Until when? It took her 3 months, 4 months before she even executed the protective order. So it just is more delay. And if you're wondering, well, why isn't Jack Smith appealing this yet? Go to the 11th Circuit. What Judge Cannon is doing is she learned the wrong lessons from being overruled by the 11th Circuit. Because she previously made an appealable order that the government could bring to the Court of Appeals to get her overturned and reprimanded, her lesson is not let me do the right thing, in my opinion. Her lesson is let me just kind of toy with these deadlines and push them back and give temporary stays of this and that, and then they'll all add up and drag this out, versus if she actually makes an order that can be appealed, like setting a firm date that's appealable, then Jack Smith can maybe then go to the 11th Circuit. But none of the stuff that she's done yet, he would be able to appeal to the 11th Circuit. The trial judge has discretion to do this. So those are the games that she's playing. But I wanted to lead with that because that's not good news for me to deliver, but that's the real news. And I want you to understand the complexity and the dynamic, the games she's playing, how Jack Smith's saying, I'm following SEPA. But then let's turn now to Washington, D.C., where you've got Judge Chutkan, who is following the law, who knows SEPA, who's like, I don't need these deadlines. I don't need these extensions. My deadlines are firm. If you want like 2 more weeks, fine, Donald Trump. And you could explain to me why you think that the strict text of SEPA isn't what it says it is, or why I should ignore circuit precedent. And I don't want to do anything that's going to move this March 2024 trial date. Judge Chutkan said that in her order. So you have this kind of chaos and confusion in Florida and this kind of firm control of the docket in D.C. Tell us, Popok, what's going on in D.C.? Yeah, and Trump brought a motion to dismiss the indictment there, too.
Yeah. So that's a good segue into it. My one comment about Judge Cannon is Judge Chutkan has made her sort of irrelevant. And Jack Smith is increasingly considering the Mar-a-Lago case to be less relevant to his focus on his major mega case, not MAGA, although it is a MAGA case too, of the DC election interference case. The reason I say that Judge Chutkan has made Judge Cannon irrelevant is because she purposely, Judge Chutkan, selected a date, hard and fast date, set in stone in the dry cement for her trial of May. Not even calling Judge Cannon to figure out whether that would somehow interfere with the what is increasingly becoming the ethereal date of March for the Mar-a-Lago trial. It was almost like Judge Chutkan said, I don't really think that trial is happening. My trial is going to happen, and it's going to happen in May. I'm not even going to respect the date of Judge Cannon. Whereas Judge Chutkan did call Judge Merchan up in the New York State Supreme Court about the Stormy Daniels hush money case to basically ask him for a little bit of judicial collegiality and let her take his date that he had assigned for his hush money cover-up case against Donald Trump. And he said, yes, of course. So Chutkan cut the legs out from under Cannon a long, long time ago in picking her date. And you can see, by the way, Judge Chutkan is running her courtroom. While she'll give a reasonable, intellectually honest decisions about dates that need to be extended, and sure, you give me a reason and a proper basis, Trump, sure, I will move a date here or there. But I am not, it is an immovable object is my date for the trial. And I will work within that, though. If you want to, the old joke about you want to move the deck chairs around on the Titanic, have at it. But we're hitting the iceberg in May. And so that's been Chutkan from the beginning. And Jack Smith, I have this working theory that will only be proven one way or the other when the memoir of Jack Smith is written, or by others associated with that trial team in about 5 years, about whether they used Mar-a-Lago as a stalking horse to exhaust and to pin down Donald Trump's very meager trial team. And I mean that in meager in every way that word is applicable, including resources, while they load up on everything related to the Jan 6 election interference. That is still and continues to be my working theory. Not that Mar-a-Lago is not an important case, becoming even more important when, as you did on a hot take recently, Ben, we learned that Donald Trump shared nuclear submarine secrets with a Mar-a-Lago member who then reported it back to the Australian Prime Minister right at the scene of the crime. It's ironic that their fight is over the skiff that's being built allegedly somewhere near the courthouse in Fort Pierce for whatever reason, and not apparently near Mar-a-Lago. That whole, it takes us time to build that. And all, this is not our problem. For five documents, get this case tried one way or the other. Stop slow-footing your case, Judge Cannon. Stop dragging your feet, which is intentional in order to give a benefit over to Donald Trump in that particular case. That's why we don't see attacks on Judge Cannon or her staff or her family by Donald Trump. And we haven't seen it yet against Judge McAfee, who we'll talk about later. Judge Chutkan, you want to move a couple of dates around? Sure. Motion to dismiss the indictment after you tried to disqualify and recuse me? Sure, I'll take a look at that. I don't think, based on what we've seen in the motion to dismiss the indictment, there is a snowball chance in hell that they're going to get that indictment dismissed on the papers, and this case is not going to go to trial. But look, they got to do their part. I'm not faulting Trump's lawyers for trying. They have to try to create possible appellate issues, and they got to preserve the record for appeal. It would be malpractice if they weren't moving to dismiss the indictment, if they thought they had the grounds. I just don't think they're going to win that at the trial level. And their bigger audiences, I think they know they're going to lose a jury trial in the District of Columbia presided over by Judge Chutkan, and their only hope is that the D.C. Circuit Court of Appeal in the future, and maybe the Supremes, bail them out of the likely conviction that's coming down the pike. And they have to operate in that particular universe. So we're just watching day in and day out the mastery of two sober jurists with intellectual honesty. One, Scott McAfee, who's presiding over Georgia, and the other, Tanya Chutkan, who impresses you and me every day. I'm on pins and needles, though, Ben, and I think it comes up next week for our reporting and hot takes along the way. And when Judge Chutkan finally gets around, now that it's been fully briefed, to issue her gag order against Donald Trump, there is no way she's going to avoid issuing her own gag order, which would subject Donald Trump to contempt and possible jail if he violates it. The only thing that I'm wondering, and I want to see your opinion, Ben, is whether Jack Smith goes through the effort of submitting what Trump did to bash and dox Judge Engoron's chief law clerk, including suggesting that she's in a romantic relationship with Chuck Schumer and that she's in control of his case, leading to a gag order from Engoron in no uncertain terms that Trump could easily violate. And does Jack Smith say, well, we know that Chutkan and the law clerks are all over this. They'll figure out what he's done. I don't have to send in a special submission. But she's going to gag him in some way about continuing to attack witnesses like Mike Pence, General Mark Milley, Georgia people, and the like, and prosecutors, their families and investigators, judges, their families and investigators, and to pollute the future jury pool, to give him a fighting chance at what our Constitution and case law provides, that he gets a fair and impartial jury of his peers. This is to protect Donald Trump from himself. He thinks, I'm going to go make a Trumper who's going to hang my jury. All you're doing is polluting the future jury. He'll be too scared of you to rule in your favor on any given day.
Well, unfortunately, we're going to have to wait until not next week, but the week after, because the hearing is October 16th, when the gag order hearing. So we'll have a week to see if additional information is going to be filed by special counsel Jack Smith's team. I don't think they're going to file anything additional. I mean, I think putting in the post of Donald Trump threatening to execute a witness who's the former chairman of the Joint Chiefs of Staff is sufficient showing. And then I think that Judge Chutkan is going to question Donald Trump's lawyers. You wrote in your brief that you thought that this is not intimidation, that you think this is perfectly acceptable. Put the lawyers in the court, ask them the questions where their bar licenses are on the line, and see what they say in a court of law. You know, I know they're keyboard warriors, you know, and they think that when they roll with Donald Trump, like Eastman and Giuliani and all the other make attorneys, get attorneys crew. But, you know, when we say here, let me just say it one more time. If you're representing Donald Trump and you go through the normal motions that everybody who's entitled to a criminal defense is entitled to have lawyers who zealously represent them. You're entitled to lawyers who do their job, try to make all of the arguments, you know, including sometimes bad legal arguments, but not unlawful legal arguments, not arguments trying to threaten witnesses, not arguments trying to overthrow our democracy. And the Trump lawyers that we highlight here and criticize and condemn are the ones that conflate their role as being legal counsel with being a criminal, with acting like Donald Trump, with acting like they are maniacs who want to overthrow our Constitution, you know, and that's why, you know what, even their argument on presidential immunity, they filed a brief to try to dismiss the indictment before Judge Chutkan, which is going to be rejected. And I don't want to even give it all that much time because it's just so utterly frivolous. But they basically argue that Donald Trump is immune from any criminal liability for trying to overthrow our democracy, because they argue in their brief that this is conduct that's within the outer limits of the role of a president of the United States under Article 2 of the Constitution, which is just beyond absurd for you to make that argument that the outer limits allows you to overthrow our democracy. And then Trump's lawyers try to analogize criminal immunity with civil immunity, which the D.C. Circuit and a district judge, Amit Mehta, have already rejected, and they've already made the ruling that his conduct falls outside the outer limits of what a job function is of the president. And as Judge Amit Mehta said, it would make zero sense if the Constitution provided immunity to former presidents who try to overthrow the Constitution. That would not fall within the sphere of what a roles and responsibilities are of a president or former president. So Judge Chutkan is going to reject that. She'll deny that, I think, relatively swiftly. Donald Trump will then try to file an appeal, an emergency appeal with the D.C. Circuit. I think they're going to reject it. And then he's going to try to file a emergency stay with the Supreme Court, and we'll see what they do. But that's what he's setting up for. So we'll be probably talking about that in a few months, and he'll try to maneuver and ask for the shadow docket of the Supreme Court to step in to try to delay the trial.
And that'll be Roberts. And that'll be Chief Justice Roberts who will make that decision, because he sits over the D.C. Circuit Court. And I don't think Roberts would make a shadow decision about Donald Trump, given the ethical pressure that's on the Supreme Court. I think he would refer that over to the full Supreme Court for a ruling. That's one good thing that came out of transparency and shows like ours, is we shine a light on the shadow docket and try to get it out of the shadows.
But if he does that, there may, again, we're talking 3 months, 4 months down the road, there may be a bad headline that Roberts grants a temporary stay, as he refers it, to the full panel, but it will be for a week or so before the full panel ultimately rejects it. So That's why I want to prepare everybody for not just what's happening now, but the way our process and procedure works, so we can just give you an accurate picture. But speaking of process and procedure, I want to go to Georgia right now, though, because Judge Scott McAfee in the RICO case brought by Fulton County District Attorney Fani Willis, he's a young judge. Hasn't been a judge for longer than like 6 months now, but he's aging in judicial dog years, if you will, because he is a wise sage on this bench right now. And this is someone who was appointed by a Republican governor who, he's made rulings that some of them have been, somewhat favorable to the requests being made by the co-defendants. Mostly they've been rejecting the gamesmanship and the chicanery and the attempts to dismiss by Trump's co-defendants. But it seems that there was this concerted effort by all of the co-defendants to kind of swarm this new judge with everything. And they threw everything at him, used every procedural rule in Georgia and local rule to try to throw him off. But he's kept steady. We have a trial of two co-defendants, Ken Chesbrough and Sidney Powell, former Trump lawyers, although I guess Sidney Powell is going to argue she was never Trump's lawyer. Good luck arguing that, even though you did 100 press conferences saying you are. But okay, that's Sidney Powell's argument. We've already got one plea agreement of one of the 19 co-defendants. We talked about that on the last LegalAF. I'm just very impressed by McAfee. Popok, walk us through some of the things that McAfee did this week as we head to our first trial that's going to be broadcast live here on the MeidasTouch Network.
They're picking a jury in 2 weeks. A jury in a case that is the criminal conspiracy against now 18, because Scott Hall has flipped and is cooperating with Fani Willis completely, and there'll be others. She's made plea bargain deals to at least 6 or 8 that have been publicly acknowledged. She will not be trying a case of 18 people or 16 remaining people. By the time she gets around to trying her case, I'm sure she will cut plea deals with at least half of the group that's pictured there. And she'll go to trial against 5 or 6, including one, Donald Trump, sometime in 2024. Because that's her MO, and that's what good prosecutors do. When she had the larger case for a criminal conspiracy involving the Atlanta Public School Board and a bribery scandal there, she had 32 people under indictment as opposed to the 19 here. She went to trial against 12, and the rest she pled out. And so we have that going on. We also have Scott McAfee, who in the beginning you and I were a little bit reticent about, because when we saw his resume, we're like, oh God, young judge, never served a day, in his 30s, never been a judge before, and was in the Federalist Society when he was in law school. But what does that sound like? Sounds like Judge Cannon. And we have the anti-canon. It's the opposite of canon. And now we know more about McAfee. I did a nice hot take on this particular issue. First of all, he's a law nerd. And he's a nerd in a lot of different ways, but a nerd that has a good sense of humor and a deadly sense of humor when it comes to making his rulings. There's a lot of intellectual honesty in how he makes his rulings. If I agree with him, I understand why I agree with him. And if I disagree with him, I understand why I disagree with him based on the precedent and of Georgia criminal practice and procedure, which he learned at the knee of one Fani Willis, the Fulton County DA. Not only did they work together in the office, he was her underling. He was her subordinate in a division of that office when she wasn't yet the DA, but was working in that office that dealt with complex commercial litigation. So he has a lot of respect for Fani Willis, and he learned his craft and his trade from her before he got on the bench, appointed by, yes, a Republican governor, but one that is an anti-Trumper and will testify against Trump in Kemp. He's a Kemper, not a Trumper. It was the Inspector General for the state, which is the chief Boy Scout for the state involved with public corruption. McAfee, and I found the clip and I used it in one of my hot takes, 15 years ago was doing a cello. He's the cellist, a classically trained cellist. They did it professionally. And there's a clip of him as a goof in a talent competition doing on an electric cello Jimi Hendrix, including, dropping to his knees and using his mouth to move the cello, when I saw that, I understood why when he rejected this week yet another, and this is now 6 or 7 motions to dismiss the indictment by Ken Chesborough, who's just trying not every which way to file whatever piece of paper to avoid the inevitable, which is his trial starting on the 23rd of October. This time, the judge sort of had enough, but rather than showing his ire, did it in a humorous way. He called the argument to dismiss the indictment because the special assistant district attorney who was handling the case, because sometimes prosecutors, even though they have big offices, they appoint for limited purposes, special purpose, if you will, assistant district attorneys. And they did for this case. And he is the lead trial lawyer for the case. He came out of private practice. And he's got he's basically deputized to be for this case only. I've done that. I've been an assistant district attorney for the Manhattan DA's office when I was a second-year lawyer arguing an appeal, which I took for practice, but I was really appointed for that position for the appeal. So it happens. They argue that he needed to take an oath, but there's an oath of office requirement, and he didn't take the oath of office, and therefore the indictment should be dismissed that he was involved with. And the judge just shook his head and said, you're not even reading the statute properly. The statute says unless it's only for a limited purpose appointment. And if it's a limited purpose appointment, you can't make the oath argument. But to pay them back a little bit, he referenced a Monty Python, the British comedy sketch team, and one of their most famous sketches, which is called the dead parrot sketch, where a person comes back to try to sell a dead parrot back to a pet shop and argue that it's not dead, it's alive. And you can tell where the comedy comes from there. And so the judge called the argument in the second half of his order, the dead parrot. And he says, continuing with the dead parrot, as if the parrot wasn't already dead, you suffered no prejudice as a result of the lack of an oath, even if you were right. The fact that he referenced Monty Python to tell him your argument is dead, yet you keep dragging it and trying to convince me that it's alive, it comes right out of a law nerd who would also play the cello in Jimi Hendrix to win a talent competition. So we like everything so far about McAfee, who is keeping this case on track. You'd think this guy had handled dozens and dozens and hundreds of trials. Judge Chutkan was a trial lawyer herself who went to trial 15 or 18 times as a trial lawyer. As a judge, she's handled hundreds and hundreds of cases since she was appointed by Obama, okay, including dozens of Jan 6th cases about Jan 6th insurrectionists. This judge, this is his first major trial. You would think that he's been doing this for like years, because he's got an answer, an order, a procedure, a method for everything that he's doing, in stark contrast to what you did with Judge Cannon, which is she's fumbling around in the dark to try to benefit Donald Trump with these ridiculous orders that we can't make heads or tails out of, even though we get this is our job to do that. And then you see McAfee. Here's a question for you, Ben. It is obvious that the biggest criminal jeopardy issue for Donald Trump, because his I'm going to be president one day and that'll take care of my criminal problems defense goes out the window, because you can't federally pardon a state prosecution. So even if he gets convicted, in Georgia, he may go to jail in Georgia and no one can pardon him. The governor's not going to pardon him, and the governor doesn't pardon in Georgia. It's a board. So why hasn't he tried to influence, I'll use that term, Judge McAfee, and to go after him in any way to destabilize that justice system and that, the Georgia criminal process? Why hasn't he done that? Even though that is really the case that presents the biggest possibility for Donald Trump to be convicted of an unpardonable crime. Why hasn't he?
I think Judge McAfee's a bit of an enigma. He is, and he hasn't made any overt ruling that Donald Trump has felt the tangible impact of yet. He will attack McAfee at some point, and we'll probably see that in the next few months. But, the usual misogynistic tendency doesn't apply there. The basically saying, New York or Democrat doesn't apply there. The kind of anti-Semitic undertones doesn't really apply there. The racial stuff that he doesn't apply there. And so he doesn't have his normal go-tos are usually based upon this kind of the hateful rhetoric. And he'll come up with something for McAfee at that time. But I think in Trump's mind, that trial as it relates to him is still pretty far in the future. So just kind of not wasting the energy there yet. I think it probably feels like it's an eternity for him because let's face it, this first trial of the co-defendants who asked for the speedy trial, Chesborough Powell, they filed more motions to dismiss this week, ridiculous ones that the judge again was like, no, stop it. You're going to trial. You wanted this. This is the speedy trial you demanded. Make your case to the jury. Stop whining and complaining to me about it. You made your bed. Now sleep in it. Is basically what McAfee said. But this trial is going to take 6 months, right? So it's going to take 6 months. And then that Trump trial, just the reality of it to set expectations, that won't take place until at earliest late 2024, probably 2025. And so he's focused on these targets. That's
well, I agree with you. Everything you just said, I agree with you. It's too early. They're keeping their powder dry. Steve Sadow, the new lawyer, has been drafting behind a bicycle race term, drafting behind literally the other lawyers who are filing papers. He hasn't really filed a substantive paper of his own yet to dismiss the indictment, but they should not underestimate the what would happen and what will happen if Fani Willis, as expected, wins the first trial, because that shows that a jury in Fulton County presented with evidence and witness as opposed to rhetoric and table thumping convicted 2 out of 19 co-conspirators for the same conspiracy. She will then learn from that. She will then use that to bludgeon other co-conspirators further down the food chain to get them to flip and cooperate as she circles and encircles Donald Trump. It doesn't mean it's not to we have a lot of people that watch around the world and also in our own about our own justice system. The next jury is not, except what they pick up in the media, is not going to know about nor be instructed that a prior jury already convicted 2 people. In fact, our jurisprudence doesn't allow that because the case has to rise and fall on the evidence for one defendant. Or how many defendants are in the room at that particular moment. So they won't know that, and there'll be a motion that will be granted by McAfee to make sure that the prosecutors don't mention the prior convictions, and they won't. But it does give Fani Willis the ability to have a major dress rehearsal before she takes her show to Broadway, right? This is she gets to improve the way she presents evidence. It's like, forget about a mock jury where we hire people and pay them to sit and listen to us as lawyers to figure out how to fix our arguments before we go to a trial, which happens, and we do. This is a real jury. And so she'll say, well, that didn't work. And I got to bring in this witness earlier, and I got to emphasize this issue or that issue, because she'll end up talking to the jury, which she's allowed to do with the other lawyers present, to debrief them, the ones that want to participate, about what worked and what didn't work in terms of evidence and witnesses and presentation. And then she'll use that like a good, like artificial intelligence keeps learning. They're learning with real intelligence about how to try the case against Donald Trump, which is always right, ever present in her mind. And so I am fascinated, I guess is the right word, that they're not trying to destabilize the justice system. They fired Drew Little, who was Drew Findling. Sorry, I was combining the 2 lawyers. Drew Findling, who was filing lots of bombastic motions to attack the justice system and Fani Willis and the court system, and they fired that guy. And the new guy, I guess they're listening to, which is keep your powder dry. Let's see what happens just in another 2 weeks when they pick a jury, and let's see over the next 3 to 5 months, whatever that jury takes, what we can glean from that and use in our next trial. It is a moment of sober approach that I thought Donald Trump was not capable of. And so I think you're right. When he finally tastes McAfee's reasoning and it goes against him, we're going to start hearing about, oh, he's a stooge of Governor Kemp who hates me, and he's just a rhino or this. But you're right, all the rest of it, the dehumanizing comparisons to animals, racist tropes, sexist tropes, Marxists, communists arguments all go out the window. And one last thing about McAfee, I caught an interview that didn't get a lot of press in the New Yorker magazine. I talk about it in my hot take with McAfee. And McAfee said two things that I think if I was Donald Trump, it would put a cold chill down my spine. He said, firstly, I joined the Federalist Society when I was in law school, but it was really a social business thing, not an ideological thing. He said it out loud. He said that, when you're a young, small C conservative, real conservative, and you're in Georgia, to be frank, the Democrats don't have an organization at the law school level the way the Federalist Society has. That's one of the great dirty secrets of the Federalist Societies. They start from the law school level, even the high school level, and then they get it all the way up to the top as they pick their judges. Democrats don't have that comparable thing. So if you're looking around for an organization and you want to become a judge one day or stay in government one day, it's natural. He said again, though, it's not ideological. It was mainly social and business. He also said, my number one goal in this trial is not to be Lance Ito, the famous dancing Ito judge from the O.J. Simpson. I want to recede into the woodwork, so I am not the story, and I am only making decisions on balls and strikes. This is not a guy or a judge that is going to be intimidated. That will backfire for Donald Trump, and this is somebody that does not want to make this trial about him. I love Judge Engoron, but there was that moment where right at the beginning of the trial, he took off his glasses and looked over to the cameras that were in the courtroom and smiled. You are not going to see Scott McAfee do that. It's the opposite of his DNA.
Well, couldn't agree more with you there. And I think it's why we get into the weeds here on LegalAF about everything that's going on, because it's not just for this episode. Inherently court cases are episodic. There's a reason why it says the wheels of justice turn slowly or grind slowly. And it's bit by bit. And I know everybody wants accountability right now. But what we've been saying now since we've been doing LegalAF for several years is here's what leads to this, which leads to this. And we get closer to real kind of critical moments like the one we finally saw in New York earlier this week with those Perry Mason moments where Trump's executives are like, we did it, we did it. Or you get a big partial summary judgment shutting down the Trump organization, or you get a conviction. There are so many people who said Donald Trump will never get charged with anything. And we were saying here on LegalAF, no, he's going to get charged. And people were saying, no, you're just gaslighting us. You're trying to give us hopium. You're just saying that. I go, no, he's going to be charged. And we said he was going to be charged in all of the cases he was going to be charged in, because that's ultimately what the data reflected. Then there were lots of people who were like, we don't like Jack Smith when Jack Smith's name was announced first, or we don't like Manhattan District Attorney Alvin Bragg. And we said, okay, you're entitled to hold those opinions, but may we offer this data? Here's what Manhattan District Attorney Alvin Bragg is doing. Here's the strategy. Here's why. Let's bring on Karen Friedman-Agnifilo, the top number 2 at the district attorney's office for 30 years. Let's see what she has to say. And by the way, she worked with Jack Smith. Here's data. You do what you want with the data, but I'm not going to be gaslighting you. I want to just show you what the data says and form your own opinions, but let's base it on facts and evidence and data. That's what we stand for here. You could certainly disagree with us, but let's agree here are at least what the facts are, not that maga-splaining that you're getting, that legacy media is unfortunately perpetuating. And so there's a lot of work that still needs to be done. There's going to be a lot of big developments over the next few weeks and months. And I know it's difficult to kind of keep this patience while all of the legacy media and right-wing echo chambers and Trump and others continue to gaslight. But you got the best team of prosecutors across the country handling the case and cases. You've got mostly good judges on these cases. You're going to have a jury who's going to evaluate most of these cases, other than the one in New York before Judge Engoron. And there's going to be outcomes that will be evidence-based, and we'll accept those outcomes, whatever they are, when the evidence is presented, and we'll keep you up to date here on LegalAF. I want to remind everybody now that if you want to support the growth of this independent media network, we don't have outside investors. So the best way that you can help, other than by just sharing these videos and making sure you let people know, which is free to do and easy to do. Another way, if you want to help the growth of this platform, though, is by going to patreon.com/MeidasTouch, which is a membership there, but it helps grow this independent media platform. That's patreon.com/MeidasTouch. Make sure you spell it correctly, MEIDASTOUCH. So go right now to patreon.com/MeidasTouch. And if you're on the fence about is the exclusive content there worth it, just look in the comments below, and I would tell anybody who's a member of our Patreon. We now have over 5,000 members. We're on our way to 6,000 members on the Patreon. So if you're a member, just tell people if you think the exclusive content is worth it. And if you think it's not worth it, that's fine. Tell them as well. But I think that we spend a lot of time trying to curate some special content there as a way to grow this platform. And some big stats to report. More people are watching MeidasTouch on digital now than watch CNN or Fox. And that's thanks to your growth. Not bad without any outside investors. So patreon.com/MeidasTouch. As always, thank you so much to everybody who's here to have such a vibrant, unapologetically pro-democracy, intelligent, compassionate community, something that I'm so honored to be a part of that you all created. So thank you, thank you, thank you. And Popok and I are about to grab some dinner together. We're both in the same jurisdiction, so we will report on that. How about I will do a post tomorrow, because I'm going to enjoy dinner with Popok right now. One of the perks about if you join patreon.com/MeidasTouch right now, I will share for you Popok and my dinner. We'll share some photos from our dinner exclusively on patreon.com/MeidasTouch. All right, Popok, I'm seeing you in about 10-20 minutes. I'll see you shortly. Everybody, thank you so much for watching. We'll see you next time on LegalAF. Shout out to the Meidas Mighty.